Good afternoon, everybody. We're going to go ahead and get started with our commercial corner for today. Today, we are going to talk about the agency relationship. We have Gary Schlechtig, who is our broker of record in Pennsylvania and our director of operations for the Elizabethtown and Mount Joy office. And we also have Scott Smith, who is our director of commercial real estate. So they are going to walk through just the agency relationship. They're going to show you how to document that properly for both Pennsylvania and Maryland. So I think, Gary, are you the one starting us off today?
Yeah, I can get the ball rolling. Can everybody hear me okay? Just give me a little thumbs up if you can.
Yep.
Okay, great.
Good.
Couple things first before we get in. I'm assuming that most of you are primarily residential agents that are planning to do a little bit of commercial or have been asked to do some commercial. So I'm going to try, because my background's residential. However, in the past, I have sold a number of restaurants, a couple of warehouses, one bar 3 times. They seem to come back to you every time. And did some work for Burger King site locations and also for a couple of solar farms, which was an interesting endeavor. So I have some commercial background. Scott is your guru, but I wanted to talk to you a little bit first about, okay, what makes commercial different? Like, why do we need a different agency relationship for commercial than we do for residential? And I think the first thing to understand is, on the resale residential end, you sign the buyer agency contract, you find them a house, you go to closing, you get paid, and you're done. Okay, that's not necessarily how it works on the commercial side. Okay, I've had situations where, particularly in the lease world, the sale world, not so dissimilar, although there's more stops in between. Once you get paid, you're paid. On the commercial side, particularly leasing, and the length of terms of the lease and the level of sophistication of the people involved, you might get paid once and done. Or you might get paid, like I did on one deal, $26.37 a month for 8 years. It was beer money and it's still spent, but it came over a very long period of time. Why was that? The reason was the landlord didn't want to pay the agents until the tenant paid the landlord. They weren't going to pay it they didn't want to pay us ahead of time and then have the tenant skip. And so, it worked that way. I've had situations where, like with the solar farms, what we basically did was my job was to go out, locate farmers that had land with certain solar properties where solar panels could be put up, and we would execute long-term leases with these farmers. And basically, once the solar farm was up and operational, they were leasing the land at $2,000 an acre for 20 years. Now, thank God those people didn't want to pay me every month for 20 years. But so think about this, $2,000 an acre. The minimum acreage we could use was 80 acres. So $2,000 times 80 acres times 20 years was a big chunk of money. And they paid it all out at once. Now, that's not always the case, but that's the way it is. So also, if you're in business parks, what you're doing with your buyer brokerages, you're cementing your pay. And there are many times commercially where your buyer client pays you. It doesn't come from the seller. It doesn't come through the seller. It might not even come through a listing broker. Scott, jump in here if I'm saying something out of line.
Yeah, no, everything that you're saying is 100% correct. And I think that's probably what causes most confusions during the transaction, is when the agents try to handle the commercial transaction like they would your standard residential transaction. That's what ultimately gets them in trouble. So yeah, definitely agree with that.
Yeah, and it's important to recognize that many of the true commercial properties will not be in an MLS system. They will be listed by a brokerage. That's may not be part of an MLS. They might not even be part of an organization. They might not be part of NAR, so they can't even call themselves realtors. And because of that, they don't have to necessarily adhere to the operational standards that we're accustomed to. So when you're playing on their field, sometimes you have to play by their rules, and it's important to learn them, because if you think they're going to conform to the way we're used to doing it, you're going to be severely disappointed. So that said, the reason we have these agreements is to make sure we get paid, so we understand what's our scope of responsibility, and when and how do we get paid, and on what. So I'm going to share my screen, and I will tell you what I'm sharing is going to be, Jen, can you pop up the commercial buyer tenant contract? So what I'm going to be showing you is the PAR version of the commercial buyer tenant agency contract. Now, I will tell you that if you're dealing in a purely commercial or industrial setting and you're being hired by a corporation as their buyer agent or as any type of agent for them, they're going to provide you with their own documentation. You may have some negotiability in terms of your compensation and when you get it, but don't have an expectation that you're going to pull up this particular document and they're going to be just thrilled that you have it. They have their own, trust me. And then you have to go through it and figure out if it's something that you can live with or not. So I'm going to concentrate primarily on the lease side of this, talk with you a little bit about the sales side. The sales side of this document doesn't differ greatly from what you're used to. But there are a couple things I do want to point out. And so let's start at the top because it's all boilerplate. Obviously, the brokerage name, your license, the client, the individual. So it's important to understand who the client is. That first line, the client would be an individual, like generally, the mom and pop person who says, look, I want to lease a corner store. And, they're just doing it in their names. They don't necessarily have a company or a corporation. That's where you put them. Down on line 9, that's where if you're dealing with an actual company, a corporation, or some incorporated entity. So you want to have the name of the corporation and then the name of the whoever can sign for that corporation. And there are not, depending on the corporation, there may only be 1 or 2 people authorized to enter into contracts. So you need to find out who that is. And it might not necessarily be the person that you're talking to. So just keep that in mind. Obviously, the mailing addresses and so on and so forth. Section 1, start and end dates. Okay. The interesting thing with this, in B, oh boy, I got a big tractor trailer going by, guys. In B, in the highlight, it actually says client will not enter into another one of these before yours ends, which I just kind of find it like, you would think that's common sense, but I find it amusing. Unless otherwise stated here. Pretty much where you see the words, unless otherwise stated here, those are for special exceptions. So you're either going to want to leave them blank because you don't have a special exception, or strike them through so everybody knows that, nothing applies here. Please don't use NA, not applicable.
Yeah, we see that a lot.
Yeah, not applicable can actually invalidate the entirety of that section. So you don't want to use not applicable. If you're like tempted to use it, I just say don't. Find some other word.
Just leave it blank if you have to.
Leave it blank. Yeah, blank is better than NA. Starting date, obviously, ending date. We have some some guidelines there for you, 6 months from then. So the rest is pretty simple. Scope of representation. This is important. Like you're authorized, and this is a piece that I want you to pay attention to. Under A, broker is authorized to act as a client for the buyer as defined by the consumer notice. And what does that mean? That presupposes that who you're talking to has seen the consumer notice. Some people think, oh, it's commercial, you don't need a consumer notice. Well, if you're referring to the consumer notice, you better have shown it to them. Make sense, everyone? All right, so we're going to jump down to scope of representation. So what are they hiring you to do? And it could be check all, it could be all of these things are appropriate. But if they aren't, leave them blank. If they're only looking to purchase a property, check that. If they're open to a lease, purchase and a lease. What if they want an option to purchase? There you go. An exchange is important. If all they're looking for is an exchange, check that box. But be specific. As specific as you can at the time. And I will tell you, I've seen a lot of people, particularly in the restaurant world right now. I don't know if you've noticed, but there's a lot of restaurants up for sale. COVID hit them bad. They went through their PPP money, and the customers have come back, but the employees have not. And they're having a difficult time running these businesses, and they're just going, you know what? I'm out. I'm going to sell my liquor license, cash out on that, and then just shut the rest of the operation down. So, be specific as to what they're looking for. What type of property? How do they want to use it? Okay, again, if they have a very specific use, you should specify that because zoning is going to dictate more where they're going to be than anything else.
Yeah.
Right?
Yeah, that's a great point. And just to jump in on that.
Yeah, please.
Here's the call that I get quite frequently. An agent will call me and say, I got a client who wants to open up, like a doggy daycare business, and they found this property and they want to know if you can show it to them Saturday at 9 o'clock in the morning. So what a lot of times they don't realize is that exactly what you just said, the zoning is going to dictate where you can look for the property. So, if I know that a certain type of use is going to require a certain type of zoning, and the property that they want to go see isn't in that zoned area, there's going to be, zero opportunity for that transaction to close. And so, those are things that need to be considered whenever you are just looking for property without knowing that first background information on, what zoning do I need for this type of business. So the specificity that you can have there is immense, because the more that you can kind of hone down into what the business is labeled as, then the more that you can micro specific your search. So yeah, definitely be specific on that with the zoning.
Yeah, that's one of the more critical parts of this whole puzzle. I'll just use, Lancaster County, Pennsylvania. I realize a lot of you aren't in Lancaster County, Pennsylvania. Lancaster County, Pennsylvania has 42 municipalities, which have 42 sets of zoning ordinances, none of them really exactly alike. So what's allowed in a given area, in a given zoning designation by right, which means you can just do it. It's allowed in that zoning. It's welcome. What you can do by right is different from one to another. What you need a special exception for is different from one to another. What's a special exception? Special exception is, well, you sort of can do it, and we might let you, but you've got to go before the zoning hearing board, plead your case, tell us what you want to do. We have to publish it to the neighborhood because if anybody in the neighborhood doesn't want your specific use that's not allowed by right into that building you're looking at, you're probably going to get shot down.
Yeah.
And
And that
then,
process may take 6 months.
yeah, and that can take quite a while.
Yeah.
Then the other option is a variance, and the variance is basically a hardship case. It's pretty hard to claim a hardship if you don't own the building, which, I don't own it. Well, how bad can it be for you if you're not allowed to do that? Is kind of the thinking. So there's steps to this, but that use and location is really important. Price range. Okay. So again, you need to be pretty specific. If they want a sale price, okay, that's sort of easy. I want it to be between $200,000 and $300,000. Okay. Lease, on the other hand, okay, you need to go, is it price per square foot? Is it the gross lease value? Is it the monthly amount that they want to pay? So if they want to pay between $1,200 a month and $1,500 a month, spell that out.
Right.
If they say, look, I'm good, I'm thinking what I'm going to cost is probably the lease itself up to $60,000 a year. That's the gross lease value. Put that in. Just be specific. Scott, anything on that?
Yeah, so that's actually one of the first pre-qualifying questions that I'll ask clients whenever I'm on the phone with them. I say, well, what's your monthly budget? And if the response is something like, well, that's going to depend on the property. That's not really the answer I'm looking for. That's like saying
it's not even true.
Yeah, exactly. That's like saying, how much does the house cost, right? Well, I don't know. It depends on where. It depends on what kind of house. Depends on all the amenities of the house. So that's usually one of the first questions is, hey, what's your monthly budget? If they don't have a ballpark, then I generally say, send me your business plan, and I'll take a look. And in the business plans, generally they have budget numbers in those. If they don't have a business plan and they don't know how much they can afford each month in a rent or acquisition, then they need to, and you need to, as their agent, advise them to the appropriate steps to take. And one of those steps is to know how much you can afford, how much your business can afford. So that's, one of the first questions that we always try to, answer before we start spending a lot of time doing the research.
Yeah. And the reason for that is because a lot of times people will come to you, particularly as a residential agent, and they'll have a dream. Okay. Like they want to do something that they've not done before. And they kind of have a frame of reference, but they don't really fully understand. Okay, who's that person? That person is, I have been a chef at a restaurant for 20 years and I'd like to own my own restaurant. I'm a great cook. I want to do my own thing. Probably most excellent cook in the world. Not necessarily the best business person. They don't always go together. So those people, while they've been in the industry or around the industry, they haven't been business owners. So when you talk to them, they have a vision of what they want the facility to look like, what they want their menu to look like, but they have no clue how to run the business. And then, you say, well, how much money do you have to work with? Well, I've got $20,000 or $30,000, but I've got great credit. Okay, let's go to the bank. You go to the bank and the bank says, okay, that's fine. That's really cool. What do you have in mind? Well, there's this restaurant they're selling for $1.3 million. Great. Based on your business plan and your background, we'll loan you 50% of the value of that business, and we'll give you a 5.5% rate with a 10-year balloon. And they're like, where am I going to get the rest? So anyway, that's part. You laughing, Scott?
No, I get that a lot. I mean, and it's not just even on the acquisition side, on the lease side as well, I have to explain to a lot of clients that are doing their first launch is the landlord is not your business partner, right? The landlord is there to have a return on his investment, his or her investment. And so the landlord may be sympathetic and he may like the business and your ideas and all that kind of stuff. But at the end of the day, the landlord's there to make money, right? Just like the business is open to make money. And so whenever we try to get too much from a landlord, either that's like in a price per square foot or a TI allowance to where it doesn't make any sense for them to do the deal, they just won't do the deal. Like they're not in it to be your business partner. So whenever they do a lease, and you kind of got to go, hey, look, the landlord's not going to do any construction. You're going to have to pay out of pocket to do the construction. And they're like, well, I don't want to spend $30,000 to $50,000. That's more than the lease. Like, well, yeah, then, that property isn't the right location for that business. So we get that a lot where they just don't look at the whole big picture and the numbers and say, how do we make this work? They just assume that because it's a lease, that they don't need any money except that monthly, that monthly payment. And that's not the case at all. A lot of times, they won't have taxes, insurance, maintenance, utilities, all that kind of stuff, which are added on to that monthly price per square foot. So, I see the same thing in leases and not just an acquisition.
Yep. So we're down to broker fee, and the fee, again, on the sales side is not really dramatically different than what you're used to on the residential resale or residential sale side. The one thing that is different, and I want to point this out in 4B, if you could see it up there, broker's fee in the case of real property, the first line there is basically your fee for selling the real estate. But oftentimes in the commercial world, it's not only the real estate that's being sold, okay? So the second line, and what are you getting paid for the gross purchase of the personal property that may be contained in the real estate that you're buying? Okay, so you're buying in the building I'm sitting in, actually in the building Jen might be sitting in, is a little bar, and it's for sale. And that bar is pretty much turnkey. It's ready to go. So when that property is sold, if they sell it as a bar or as a restaurant, there's going to be a buyer, a seller, a buyer's agent, a seller's agent, likely a buyer's attorney, a seller's attorney, and both of their accountants involved in this transaction. Because not only are they selling the real estate, they're selling the business, the trade name, and the equipment in the building. Those during this sale will all be broken out into different cost bases. So it's important if you're selling a property and it's to include all the stuff inside of it, that you make sure that you cover yourself, that you're getting paid on the stuff inside too. Does that make sense to everybody? I can only see 4 people. So if that makes sense, just nod.
Yeah.
So that's important. That's not one that you want to skip, particularly if you're selling some type of turnkey operation. Again, we're going to roll down broker's fee, C, broker's fee in case of a lease. Okay. Broker's fee is, we've put some minimums in there, and it all depends on the gross value of the lease. And for the entire term, and you want to put in your flat fee, unless otherwise stated here. Again, leave it blank or strike it through unless you're having some kind of special side deal. D is one that you're probably not used to, and that is broker's fee on renewals or options.
Yeah.
Okay. And that's one that, like, particularly if you're in a business park or a commercial strip center or some type of developed commercial office space, oftentimes built into these leases is a renewal option or a buyout option, depending on if it's a condo space. And so the question is, are you getting, if at the end of 5 years, the tenant that you brought to them renews, do you get paid again or not? Now,
That, Gary, that's very, very important. So as someone who does a lot of these, you may come in being the second broker in that transaction, by way of renewal, right? Well, if the broker before you did not put in any kind of retainer or fee on a renewal, then the chances are that the landlord will not pay you a commission, because they're going to say, we already paid the commission to get the tenant in the property, in which, even though you had nothing to do with that, you may be representing that tenant now. That means that the landlord will not be compensating you. So you should make sure you're being compensated somehow. But if this paragraph was left blank, or a like kind paragraph meaning the same thing was left blank in another document that you're not privileged to, you may not be getting compensated from the landlord.
yep. Yeah, real important. And the other thing is you have to kind of track that, by the way. You know, like if you're going to do something like this, you want to put some kind of note in your CRM or your calendar to touch base with the tenant, you know, 30, 60, 90 days before the end of whatever their lease term is. Because I guarantee neither the tenant or the landlord's going to come running to you waving a check, thankful that the tenant renewed.
Right.
You usually have to go after it and say, hey, you know, Bob and Mary, are you intending to renew, or should we start looking for a new place for you? Which is good follow-up, by the way.
Mhm.
If they say no, we're hoping to renew. We haven't approached, you know, we'd love to stay here. That's when you kind of reinsert yourself and make sure that if you are getting paid on the option, that you're there to get paid, because they're not coming to you. You'll need to come to them. Scott, anything on that?
Yeah. So this is similar to your drip campaigns in the residential world, right? We just do it in a much more non-frequent basis. I would say if you know that their lease is set to expire in 12 months, you need to be on the phone now, because there may be timelines built into that lease to where they have to notify the landlord of their intents.
Mm-hmm.
So some may say you're going to have to give us notification 180 days before lease expiration on your intent. All right, well, 180 days is 6 months, right? So if they have to notify the landlord 6 months before their lease expires and what they intend on doing, you need to be contacting them 6 months before that, so you can actually do the work to see if A, they're getting the best rate possible in the market, or B, is there other opportunities in the market that may be more favorable? Okay. And if that is the case, then that's also ammunition to go to the landlord and say, hey, look, we're paying $25 a square foot on this lease currently. New inventory in the market is coming in at $20 a square foot. Those landlords want us, and we can go there and save $5 a square foot. What can you do? Right? That's looking after your client. So that's kind of how we do that, which is very similar to like how the residential agents will send out holiday cards or birthday greetings or whatever the holiday is of that stuff, or, activities to do in the summer, or whatever the drip campaign consists of. That's what we do in commercial. We just kind of say, annually, like once a year, hey, how are things? How's those end of the year expenses going? Do you need any help doing a lease audit? How's business? That kind of stuff. So we're only going to touch the clients, once a year maybe, versus once a month in the residential world. But similar to what you're already doing in that aspect, just, not as frequent and with a little bit more meat.
Cool. The section 5, payment of broker's fees. I think you can all pretty well read through that. And we did include, Pennsylvania has a user's guide for every document they have. And the user's guide for this particular document is very thorough. So that's available to you on the PAR website. Or Jen, are we going to put that on .loop? Put that on .loop?
I am not sure if it's in .loop or not, but we can get it added. It is when you guys go into Home Sale Center to that commercial corner tile. It's in that Google Drive folder with all the other commercial corner resources too.
Excellent, excellent. So I'm not going to cover A and B. They're pretty self-explanatory. Did want to touch on C a little bit. I don't know that this happens very frequently. What happens in the case of the seller or the landlord defaulting? Well, on the sales side, we typically know what's going to happen if the seller defaults. On the lease side, why would a seller default? I don't know. Maybe they entered into a lease and they went belly up. Maybe other tenants in the building aren't paying them and they're in foreclosure. I can't really come up with a good why would a seller, refuse to go along with the terms of the lease. But here's the bottom line. If the seller, let me use the right words. If the landlord defaults on a lease, the tenant has ramifications. Like they can take them to court for damages. They can take them to court for maybe future rent because now they have to rent something at a higher level. This section's designed so that if the tenant gets money from the defaulted seller, that you're entitled to a piece of it. Now, that doesn't necessarily mean we're going to collect it. We could. It's our option. It's there to make sure that in those situations where I use my example of $26.37 for 5 years, okay, a month for 5 years. Okay, this could have been a 10-year lease. Seller defaults on it. The buyer gets a $100,000 judgment. The seller pays them. Tenant's happy. What do I get? The 200 some dollars I got so far, right? I did the work. It's not my fault the seller defaulted. So that's what that section's for. We have some suggestions in there for you, but that's, we don't actually have a policy on it, frankly. But that I think is some good guidance. And then Scott's got a lot of material to cover. The rest of this is really boilerplate, and you can read it in. It's pretty plain language, and if it's not, the user's guide does a really good job of explaining it. Does anybody have any questions before we move on to some of the Maryland forms? Nope. Great. Either we did a great job or just went. All right, Scott, you're up.
All right, awesome. I apologize about my technical difficulties. My camera is not operational. It may have something to do with switching back and forth from Zoom to Google Meets. I don't know, but we will have that repaired for next time, no doubt. Jen, if you could pull up the hold harmless agreement there, that would be excellent. Okay, So crew, this is a Maryland real estate document, which is for, I believe it's Prince George County, which that county in Maryland tends to be on top of it with their documents. They actually have a lot of the commercial listing documents and things like that. And so I don't know if y'all are familiar with the concept of what a hold harmless agreement is. So I thought that would probably be a great place to start. And this is a scenario that happens a lot with first-time commercial agents, as well as maybe first-time commercial buyers or tenants. And they will ask the agent to fill out or to, get together and submit a commercial contract on behalf of them as part of their agency relationship. Well, the problem is in commercial, about 90% of the time, we don't use the boilerplate documents that you would find in your county forms, okay? And the reason for that is in commercial real estate, everything is pretty much done by attorneys. So attorneys will draw the documents, attorneys will draw the contracts, attorneys will draw the leases. So every aspect of commercial is pretty much touched by attorneys. So when we don't have the legal understanding of some of the terms, the amount of addendums that would be needed to correctly and adequately fill out that contract would be presume that you would be practicing law, which, as you know, as a licensed real estate professional, we don't practice law. We don't operate outside of our scope because we're not licensed and insured to do that. And we're not looking out, primarily, we are not looking out for the client's best interest if we do that, okay? So anytime whenever I see an agent either in Pennsylvania or Maryland, and they say, hey, we need you to draw a commercial contract. My first question is always, do you have an attorney? And if they say, no, we don't have an attorney, or yeah, we advised the client to get an attorney to draw the contracts, and they declined, and they said they didn't want to pay for the attorney, that they wanted us to do it. That should be like a huge red flag, right? And so one of the things I always recommend is if they are going to request you to operate outside of your scope, and you've advised them that it is outside of your scope, and they still want you to do it anyway, then they should at least be comfortable with signing a hold harmless agreement, okay? So I wanted to review the nuts and bolts of a hold harmless agreement. This specific document, which is in the PG County, Maryland commercial document forms, has some pretty good nuts and bolts in which you could have an attorney, or maybe you yourself could customize it with supervision of your broker or office manager. But I just wanted to go through the components of this and understanding why we have a hold harmless agreement. Is it going to keep you from getting sued? It is not going to keep you from getting sued. Will it provide some assurance if you do get sued that you advised your client to seek an attorney to draw documents that you were unfamiliar with and they declined and asked you to do it? This document will at least identify that in a court of law and hold you, quote unquote, harmless for the anything that goes wrong in that contract. So it's very simple. The buyer should reflect the same buyer in your brokerage agreements, buyer's agent or tenant's agent, buyer broker, our case, Berkshire Hathaway Home Services, Home Sale Realty. property known as, and then whatever property address in which they are asking you to write the contract in. And it just says that, hey, the undersigned, being the buyer, we are aware and we are advising the buyer to engage in due diligence of respect to the purchase of a property. Due diligence should include, but may not be limited to, like viewing the property, engaging real estate appraisers, any inspectors or engineers that may be needed, licensed surveyors, professional engineers, environmental attorneys, property boundaries, any material aspects of the property. And the buyer would be either present or not present while these items in the due diligence period are going on, and that the buyer acknowledges that they have elected to either not be present, or this is, in this case, as it relates to the documents, the buyer acknowledges and have elected not to have an attorney draw the contract documents. And despite the buyer broker's advice to the contrary, right there in the document, despite the buyer broker's advice to the contrary, buyer further acknowledges and recognizes that the buyer broker and any sales associated affiliated with the brokerage are not inspectors, real estate appraiser surveys, i.e. experts in a commercial transaction, okay? And then it says, in consideration of the above, the buyer agrees to solely responsible for the buyer's decision to write an offer on the property. And then the buyer agrees to hold harmless and defend in indemnity the buyer broker, buyer's agent, and any sales affiliated with the buyer brokerage against all claims, right? So this is, your clear-cut document. We've advised you of these certain things, and you have decided that you did not want to do that, and you wanted us to perform these services, and we are not held liable for any malfeasance. So whenever I tell agents, hey, you're going to need a hold harmless agreement, this is exactly what I'm talking about, which basically just says, hey, we've advised you to get expert advice from an attorney, and you said you don't want one, so that's fine. We have forms, boilerplate forms, that we can have you fill out. We have those in Pennsylvania and in Maryland. But I can't be held responsible for anything or neglect anything in that document. So just be aware when we say do a hold harmless agreement, this is what we're talking about. This is really the first step before you write the contract, right? So just so we're aware about that. Okay.
And
Any questions,
by the way,
comments, concerns on that?
Can I just jump in there, Scott?
Yeah.
That's, if they say, I don't want to pay an attorney, that's kind of your first warning signal that there's a bumpy road ahead. Like, if they don't have $250 to run a document by an attorney, how are you successfully going to operate any type of business anywhere?
Yeah.
Think about that. And we get that. We do get that a lot. No, the line will be, oh, I thought that was your job. Well, it can be, but wouldn't you rather have a professional do it? I mean, I'm not an attorney. I'll look out for your best interests as the best I can. But these standardized documents don't cover every situation. No. That $250, that's an awful lot of money. Guess what? That dog washing operation is not going to work out.
Exactly. And I hate to sound mean about that, but I mean, it is, that's the truth. That should be a major red flag. If they're like, well, I don't have the money to afford an attorney, be like, well, do you have the money to close the transaction? Like, that should be a major red flag. Jen, if you could do the understanding whom the agent represents. Yep. Okay. So this is the same form that probably, if you're in the state of Maryland, it's a Maryland Real Estate Commission form. And it basically talks about who you represent in the transaction. So Maryland is a weird state, right? I don't know what state y'all are residing in, but Maryland is what is known as a common law state. So I'll give you a little history here. So a couple years ago, I guess it was 10 years ago now, the Maryland Real Estate Commission said that anytime that a realtor wants to renew their license, they have to take agency as part of their continuing education requirements. So in Maryland, anytime you renew, that's what you got to take. It's the same agency class that you've probably taken a million times. You've been licensed for more than 2 years. The problem with that is they quickly realized that the agency class that they have in residential does not apply to a commercial transaction, because in Maryland, being a common law state, we follow a different set of laws for commercial property, which means agency changes in commercial. So they set up a commercial agency class that you can take as a residential agent for CE credit, and it will count towards your agency requirements for the state. I am one of the 14 instructors that we have for the state. And so if you haven't taken that class and you want to get into commercial in the state of Maryland, I highly recommend that, because it goes into depth about commercial agency, how it's handled in Maryland. And I can tell you, just by the zoning change of a property will change the laws that you have to follow, because even if it looks like a house, if it's zoned commercial and the use is commercial, it's in a commercial area, even though maybe the house was built in 1910, it's always been used as a house. Area around it has changed. That is a commercial property, and the laws that you have to follow will change in the state of Maryland. So take the commercial agency class if you want to. This document, State of Maryland Real Estate Commission, understanding who the agent represents. It goes into what is a seller's agent, what is a sub-agent, the buyer's agent, and then dual agents, right? And everyone knows what a dual agent is. And I would just like to say, a lot of people think that being a dual agent is illegal. And I can say it is not illegal. In Maryland, it's actually in COMAR, which allows for it. What creates the dual agency being illegal is when it is not disclosed. When you have an undisclosed dual agency arrangement, which is acting for two parties in the same transaction without consent, and I have to say informed consent, not just consent. So you can't just slide this understanding who the agent represents document in front of them and have them sign it and not actually go through what consent for dual agency means, okay? If it is an undisclosed dual agency relationship, you can lose your license. You can be fined when you go in front of the real estate commission. And the big kicker is the transaction can be rescinded, which means they can undo the transaction as it was before the transaction ever occurred, which includes giving back your commission. So no one's going to be happy about that. That does happen in Maryland. I've heard it happen several times. So just be aware, those are ramifications of what can happen if you do not have a disclosed dual agency document, or put in a document, whether that be actually baked into the contract or the lease, explaining what the dual agency arrangement is. So like in this case, it says that both seller and buyer agree to dual agency. by signing a consent for dual agency form, the dual agent, the broker, or the broker's designee shall assign one agent to represent the seller. Right? If either party does not agree to dual agency, the real estate company must withdraw the brokerage agreement for that particular property. Okay, so if they're like, hey, no, you're only going to represent me, I don't want you representing both parties. Okay, then that's fine. Then you may not be able to get that property. So, and this is real simple. We, the sellers, landlords, or buyers tenant acknowledge receipt of this disclosure, and they can say right there, you can check more on who you represent and the name of the client. It just kind of identifies the terms of the agreement and gives an explanation as to what dual agency is and gives you the opportunity to open that dialogue with your client. So I think this is required as part of this is really a Steve Mazzaro's question, but this is required as part of the Maryland contract. And then the last one we want to go over real quick, because it is important, is the consent for dual agency form. And it talks about, what dual agency is and gives a better definition on how to handle dual agency and what happens if you refuse. So your choices concerning dual agency, consent in writing, it has to be in writing, can't be assumed. And then it goes into the duties and talking about intercompany agents and the best way to handle that. So be aware that those documents exist, and all of this occurs before you're even writing the contracts. So this is a big thing in commercial on understanding who you represent. Keep it straight, keep it legal, keep it above board, keep the documents in line. There are a bunch of other documents in which we will go over in future commercial corners. We plan on going over a sales contract. We plan on going over a lease. I believe we're probably going to go over compensation agreements and talk about not just when you're going to get paid or how much you're going to get paid, but the appropriate way to guarantee that you get paid. And so, yeah, that's commercial agency for Maryland. And I believe those similar forms exist in Pennsylvania as well, if I'm correct, Gary. It's just a different state name on those documents. That sound right?
He had to log off, Scott.
Oh, he did? Okay.
He snuck out.
Awesome, no problem. But those are for Pennsylvania too, correct, Jen? Is that
Which ones?
there are agency documents in Pennsylvania as well?
Yeah, they
Yep.
have the one main buyer tenant agency contract, and there's a residential and a separate commercial version. So they're all in dot loop for them.
Okay, awesome. Yep. So all those are in dot loop as well. Any questions, comments, concerns?
No, and those cheat sheet forms are in that Google Drive folder. So you just go to Home Sales Center, Training and Education, and then click on Commercial Corner and can get to copies of those so you have them to refer to.
Awesome.
All right. Thanks, Scott. And thank you to Gary, who had to sign off a little early for us. Thank you guys for tuning in, and then we will send out the invite for next month.
Awesome. Thank you.